one of the key parts of estate planning is to minimize or avoid or strategize around taxes. And in California, we have lots of tax issues. Fortunately, we have with us today a real expert in estate planning as it relates to real estate taxes, attorney Joshua Ramirez. Joshua, thank you again for coming on our program.
Thanks for having me, Bill.
What's the biggest challenge that you see or the biggest mistake that you see people make regarding taxes in estate planning, or I should say in failing to plan for an estate?
Oh, yeah. Right now, the number one mistake I'm seeing is not planning for Prop 13, Prop 19, property taxes.
And so you say 1319 because the 19 modified 13 as it relates to inheritance, correct?
That's correct. Long story short, for 40 some odd years, we had Prop 13, right? From the 70s all the way until really the 2020 election. February 2021 rolls around, and we now have Proposition 19, which actually modified Prop 13 extremely heavily.
And I think that one thing about California is if you find a way around the taxes, it can work for you business-wise. But if you have to pay the full tax load, it becomes crushing. So describe the change that Prop 19 made as it relates to inheriting property from a Prop 13 point of view.
Yeah, so whoever inherited property before 2021 probably has experience with this, probably from their parents. You can take your parents' house, commercial properties, rentals. You used to be able to keep their property tax bill. It stayed the same. So now your inheritance, you could turn those into rentals and have a nice little nest egg there. After February 2021, now that we have Proposition 19, that gift from California goes away. So the property does get reassessed if we don't do any planning. There's one little exclusion. And this is pretty rare, Bill, but if you have, you're inheriting your parents' primary home and you move in there within a year of their death as a child, you can keep their property tax. But as you can imagine, that's a small segment of the population. Most people aren't going to move into their parents' house. They already have a house.
Right.
So these properties, the primary residence, secondary properties, commercials, they all get reassessed. And you know what kids are doing is they're talking to me in my office. They're crying because they realize we thought we were going to turn these into rentals, and we thought this was going to be our retirement. We didn't realize our property tax bill was going to be 20 grand a year, 25 grand a year. And now they're liquidating.
And so what you're talking about, and I see this in my neighborhood, that I have neighbors who are buying a house new, which in essence, if you inherit the house, it could be reassessed at its current value, and they're going to pay property taxes based on, say, a $2 million valuation, which could be $20,000, $25,000 depending on where it really falls out, versus a neighbor like me paying $500 a year because the house has been assessed and locked in on Prop 13 for all these years. And it's a lot of money. And that could be the marginal difference between making a property make sense as a rental property or not. Now, there's other issues too, though, right? Because you sell a property, there's perhaps taxes due, maybe not, depending on in LA. If it's over $5 million now or $5 million change, there's taxes due. So these become kind of holistic evaluations rather than just one question, right? You can save taxes one place and end up paying more through another place.
Yeah, that's exactly right. And that's why we need to do some careful planning. For the past ever, when we do estate planning, we would always talk to parents. Kids aren't allowed as part of the conversation. Whatever parents wants goes. That's still the case with the big asterisk of, I need to know what your kids are going to do. And every child might have a different answer. Child 1 may want the house, may want your commercial building. Child 2 may want to liquidate and move to the Bahamas. I don't know. So we not only need to look at what do mom and dad want, we want to look at what each individual child wants, what their long-term plans are, and we can design amazing plans. And every family is going to be drastically different.
One of the questions I had in kind of preparing this was, what constitutes the primary residence, right? If it takes the child making that the property their primary residence, we all have seen cases where politicians maybe have houses, say, in Washington, D.C., and then their local area, and maybe they have a third home in a vacation area, and they can designate, one or the other as their residence. And you go, well, that's funny because he spends more time here or they spend more time there. I know it's an issue now, without getting too political, certain politicians who are writing off properties and rental properties and such. So let's talk about, though, as it relates to this issue, what constitutes a primary residence for a child inheriting property from their parents? Can they have a house with their kids in it in Tarzana and claim their parents' house, their primary residence in Encino or Beverly Hills, or is that, what has to happen to make that claim?
Yeah. So the way I phrase it to clients, because I get that asked all the time, the way I phrase it is, first, are you willing to commit perjury over this? What's actually the truth? Before we get technical requirements, where are you really living? Where are you sleeping? Sometimes that is in 2 locations throughout the year. That's a legitimate thing, but where are you really living? That usually solves the problem. That answers your question. But I'll tell you some factors that I tell clients. If they say, I'm going to use mom's as a primary residence, are you ever going to rent it out? If so, it's not your primary residence. You're renting out a room? Maybe, but people typically don't rent out rooms in their primary residence, especially if they have a family living with them. But it's really where you live in most of the year. This is kind of the basic test. But I will grow clients. Ultimately, it's up to you to submit the form. I mean, we're going to prepare it for you, but it's up to a client to sign a form and sign it under penalty of perjury. This is my primary residence. Is
it reasonable for somebody, say, to have I think like a second home environment, maybe commonly in Palm Springs, let's say, or Mountain House and Beach, Lake Tahoe, where, mathematically you might spend more time at the house with the kids in Tarzana, but you do spend, 2-3 weeks a year in the cabin. Is the mathematics the majority? Is that the criteria, or is it, where you feel your residence is, or can you just simply file a homestead and declare that your residence?
Yeah, so it's where you're going to spend most of your time, and it's where you're going to file your homeowner's exemption. So that's the key document. So if you already have one and you say, well, I'm going to move into mom's house, we're going to remove your homeowner's exemption from your current house and apply it to your new house you're moving into. You can only have one homeowner's exemption. So that, and I also find a lot of counties in California, that is kind of their test. It's not really the law, but that's one of their factors is
right.
What's going on with the homeowner's exemption. That's also how they look at what was mom or dad's primary residence. If mom or dad had 2 or 3, we don't just get to pick. Where did their homeowner's exemption, where was that filed? Again, we can argue around it, but that is a big factor for counties.
Mm-hmm. My experience, and I think we talked about this before the last time you were on my podcast, my experience as a real estate agent is that the County of Los Angeles, every single transfer challenges it by default. It's almost like they ignore, I forget the form that you file for the transfer of ownership. And I have customers who fill out diligently. They call their attorney or their accountant, and every box is done. They turn it into escrow. They make sure it's there. We keep a copy of it. It just seems to me, in particular, Los Angeles County just ignores it and just reassesses and says, we're reassessing based on the current market. Go ahead and prove us wrong. Is that just what it looks like, or is that really happening in your experience?
That does happen sometimes. Tell you, especially when we're in this Proposition 19 realm of planning, that happens, and it's for us to explain. Mm-hmm. At least our firm, we try to get ahead of everything, so we just don't fill a form and tell a client, let us know if they contact you. We fill out a form and submit information if necessary. So we might submit a trust with the form. We might submit an LLC or operating agreement with the form, or a letter explaining what we're doing. So we get ahead of it to stop that potential reassessment. The good thing is, and LA County is notorious for this, but if they reassess erroneously, we can reverse it and get you back to where you were, and they'll get you a refund. There's 2 problems. You'll be out of that money for a year and change, and you got no interest on that money, and that could be 10, 15 grand. And of course, they're never going to apologize, and it is a pain in the butt trying to get money from the county back.
Well, but also a reassessment that's wrong, while it might be 1 year by the time you get it back, if you don't challenge it, it would be every year. Plus an increasing amount on top of that every year going forward. So sometimes people might say, well, is it worth spending in attorney's fees $5,000, $10,000, $15,000 to save $15,000? And the answer is no, probably. But if you're talking about $15,000 a year for 5 years, that's a good return on your investment. That makes more sense. Now you got to sell customers or clients on making that assessment. But to me, I've seen this happen over and over again, and I don't see as many reversals. Customers on their own. I just see that the same customer calls you back every 6 months for more comps. And it's like, maybe you need some professional help on this. I'm not that person. I can give you data, I can give you information, but in terms of your rights and the forms and such. So talk about that a little bit. What's the process look like? Is it, again, I understand you want to get in front of it. In those cases, you'll never know. Hopefully they accept your information and you don't really know that it's a problem because it wasn't a problem. But those that become a problem, how many times does it take? How many at-bats does it take to get the thing knocked on track? Is it a one-time thing commonly, or is it, because to me it looks like it's a battle when a customer tries to do it on their own?
Yeah, so here's what I'll say. So most of our consultations right now are about Proposition 19 planning, avoiding property taxes. And most clients that we speak to and do consultations with do not move forward with the planning, and it kind of surprises me, because if their kids were in the room, the kids would say, Mom or Dad, I really want to save the property taxes. But sometimes parents don't think that far forward. And one problem, Bill, you mentioned is fees. Yeah, it costs money to do Proposition 19 planning. Absolutely. And it's more than a normal estate plan, what you might spend your normal trust with. But if we were saving just 1 year property taxes, saving your kids 10, 15 grand one time, you don't hire a lawyer for that. But we're saving it for the rest of their life. So when a client passes away and their kid's 60 years old, we're talking 30, 40 years of 10, 15 grand a year, talking $500,000 to $1 million of savings for their lifetime. Plus we get to roll this over to the next generation. So we could be talking 7 figures, and the more properties you have, the more we're going to save you. So we always balance attorney's fees. There's a few balancing things we do, Bill. We balance attorney's fees and time and stress and risk with also how much are we going to save your children. And there's multiple taxes we consider. We consider property taxes, estate taxes, and capital gains taxes. And that's why I like to have family meetings to discuss this. So to your point about clients doing this themselves, I have seen clients have a consultation, try it themselves, and guess what? They're calling me because they messed this up. Proposition 19 planning is not as simple as going to Walmart and buying a deed. Your kids will be very angry with you after you pass, if that's the plan, or actually within a year. So Proposition 19 planning, not many attorneys do it. There might be 3 to 7 firms in SoCal that can do it very well, and we're one of them. But yeah, Bill, Prop 19 planning, that's a huge practice area right now.
And I would imagine when you get into a specialized area like this, you become the professional to the professionals, meaning I would imagine most of the inquiries are not coming from consumers. They don't even know to ask these questions, but probably an attorney who does a lot of the estate planning but doesn't have this particular expertise.
I'd say 90% plus of my referrals and clients come from other estate planning attorneys.
Yeah.
Estate planning attorneys are smart to realize, I don't really know this exact area. Let me refer to Josh. And so we do offer consultations by phone to anybody who wants to talk about avoiding this for their children. Within about 30 minutes of a call, I will tell you if this is a good plan or not for you.
It seems to me, having worked on a couple larger estates, when they get large and complicated, you have several what I would call kind of major issues pop up, right? This could be one of those areas, and there's a couple other maybe depending on the state. And it seems like when I work with them, the attorneys who are effective are the ones who bring a team together and don't try to learn on the customer's dime some of these special areas that may not come up all the time, meaning I don't care how many estate plans you do, the Prop 13 opportunity may not present itself all the time. But if it does, it's potentially a big savings. You have a $5 million house in Beverly Hills that you can keep in the family, and maybe after a year or two, turn it back into a rental or something. It becomes very valuable as a source of income for the future generation. And so on one hand. On the other hand, I see oftentimes attorneys try to do too much. And I know my specialty is probate. My specialty is not estate planning, though in estate planning often they have to sell something. That's where I get involved. But I can just kind of tell that some of the attorneys are kind of over their head on this. So what do you think it is that gives attorneys the opening to call you to say, hey, I don't really understand all this. Is there an opportunity here to save some money or not?
The thing where smart attorneys will end up calling me or referring me a case, that they're talking to their client about doing their trust. It's usually where it starts. Well, they'll realize, oh, this is not just going to be sold and split three ways. One of your children has a disability and wants to live there, or one of your children never bought a house and wants to live there, or one of them just wants to keep it as a rental. That's where they refer to me, because it's very complex. And funny you say, very large estates. Very large estates have this problem because now we have commercial properties and rentals and all sorts of issues that we need to balance. But also very, very, very modest estates. Just one house, $500,000 house has actually just as large problems, because now you have a $500,000 house and not everybody's wealthy in the family, and there's three kids. Where do we get the money to pay off each other?
Right.
Because remember, part of our planning in the law is when it's a parent down to a child. That's where we get to take advantage of some of these laws. If a parent leaves property to their three kids and says, let's figure it out later, and one child says, well, I'm going to start buying out my siblings and getting loans and mortgages and borrowing from my 401k. Well, guess what? That's not a parent-child transaction. That's a sibling-to-sibling transaction, and those get reassessed. So biggest mistake, and actually one of the biggest takeaways I want people to understand here is, please do not just say, I'm going to leave my property to my kids three ways equally, four ways equally, and they'll figure it out. That only works for people who have huge dollars amount, where child one can get a $500,000 house. Child 2 and 3 got 500 grand from your trust. Most people don't have that kind of cash sitting around. So if you're really trying to plan for this, please do not just let it go equal to your kids. We will regret that long term. Let's have a conversation and figure out how to plan for each other.
Well, especially when you use the number 3, and I see that as kind of the magic number where a problem starts, because if you have 2, one can decide they want cash, one can want the house, they can work it out. Once you get 3, you have 2 more personalities, not just one more. And now the one remaining is a minority. They only have 33% interest in the property. Very hard to finance 67% if you don't have income, if you don't have a track record of owning property. And typically, the child that wants to live in the house has been living there, never bought a house, never financed the house, doesn't have the capacity to. And that seems to be the magic number for me that becomes a problem. And then you have, they don't want to sell, they'll undermine the probate, that becomes a problem. So the estate planning issue, it becomes critical, like you say, at the smaller level. There's less money left over to deal with. The attorney's fees become a bigger piece of it, but they do the plan ahead of time. So I imagine one of the options would be, like you say, to designate the property to one, and then the other 2 to get some sort of cash, whether it be a loan or maybe life insurance or some other way to pay them out.
Bill, in a perfect world, that's a very easy plan. Doing this as long as I have, that almost never works out. 99% of the time, that's not how it works in real world, because 2 problems. People just don't have the cash sitting there.
Right.
It just doesn't happen. People don't have $1 million, $1.5 million liquid just sitting there. Even if they have a couple $100,000 in their IRA, that's separate from the trust. We have issues. So people just don't have the liquidity to do that. But the other problem is something you mentioned, qualification for loans. So we can't just say, well, let's take out loans. 2 reasons. Again, I go back, sibling to sibling transactions get reassessed. So this whole loan thing is not going to work. There are ways around it. That's where my specialty comes in, and there is kind of a little wiggle room for loan issues. But also, if that child never did buy a house, there might be some underlying credit issues and income issues and asset issues. And those issues lead to they're not going to qualify for a loan. And so sometimes we just have to have very, very awkward but blunt conversations. Your child does need this house. Yes, they cannot afford it. And sometimes that's the answer. And to your point, life insurance, that would be a great tool to help equalize the distributions and let everybody inherit. But the problem there, again, is most people are calling me later in life, not going to qualify. So they're calling me in their mid to late 70s. They're not going to qualify for a good rate. And the other problem that I see, even if we can qualify, parents tell me, well, Josh, yeah, I see this policy. I can buy it for $2,000 a month for this whole life policy. Why the heck would I do that? What's in it for me? And now I'm dipping into my IRA and retirement and cruises and everything for what? Theoretically, the kids should be paying for this. But I will tell you, kids are sometimes short-sighted too. They're not going to outlay money for life insurance even though it's going to save them 20 times the amount throughout their life, they're not going to spend the money right now. And so sometimes the answer, Bill, is we go through all the planning and there are lots and lots of things we can do. But for a lot of people, at the end of the consultation, the answer is the kids are just going to sell and split. And that's fine. That's a fine answer.
Well, they can't sell and split unless there's an agreement. Somebody has to be the administrator, has to go through the actions. I'm sure you get the same phone calls I do, which is my brother's the administrator. He's supposed to sell the house. It's been 2 years. I have the information. It's interesting. As I was listening to you, I was saying, I just have a great solution. I have another podcast on reverse mortgages. There's a downside reverse mortgage, which is mom and dad get it. They pass away. They leave the house to the kids. Could be the same situation. You have 3 kids, assessments and all that. But the positive is the reverse mortgage is forcing the sale. And so while if you might give them a portion of it or however you want to manage that and say, well, you should sell the property, with reverse mortgage, it's going to get sold one way or the other. And it seems to me it also creates opportunity to pull some liquidity out ahead of time to provide for some sort of ease of the process. So I don't know, is reverse mortgage something that you ever work into estate planning? But it seems to me like that kind of forces the issue. You can say you want to live there as long as you want. The bank's not going to let you. They're going to get the house back one way or the other.
Yeah, no, I am a proponent of having conversations about reverse mortgages. Sometimes they're the boogeyman in the room, and it's just re-educating people. Yeah. I see that they're great tools for funding long-term care, funding immediate needs, funding repairs on the house, all the things, putting railings and ramps and all the things we're going to need as we age. They're also great when it's time to downsize. We could do a reverse purchase, right? And you can kind of help downsize them into maybe a senior community. So there's a lot of benefits for reverse mortgages. It does keep the peace after somebody dies, which is kind of funny because it'll probably be sold. But all of this, Bill, it always goes back to, it starts with planning. Right. And a lot of people pick up the phone or come into the office and start with, 3 ways equal to my kids. But that's not the way we should be thinking about estate planning in California anymore. We all know you love your kids and we want to leave it equal. We need to now think, what do you have and who gets what and what are their goals? Don't just say 3 ways equal because that's a recipe for not only making sure everything gets sold and split or reassessed, but it is a recipe for fights. And it's funny you mentioned, kids not leaving the house or the administrator or trustee, supposed to sell. One of the most common reasons we're in court, probably the top 3 reasons. That one of them is the trustee or somebody is living in the house and refuses to leave. And I will tell you, I can't tell you how many consultations I'm on, Bill, where I asked the client, well, when did your mom or dad die? And they go, 2 or 3 years ago. Why did we wait so long? Within that first or second month, your brother or sister's not getting out of the house. It's time to call somebody like me. We don't need to rush to court. We can start with letter writing and we can take things slow. Please don't wait 2-3 years. That's bananas. Then we're gonna have capital gains issues and a whole host of other issues. I have a client right now where a very similar story happened and it was up in Pasadena and now the house burned. Now we have a whole host of other issues. So yeah, if there is a trustee causing issues or not leaving the house or even a beneficiary, let's pick up the phone to myself. Let's talk about what this path looks like. Let's start getting on the train. It's a long train ride to resolutions.
It's a long train ride. It's not fun. You're not in the first class car sipping champagne and eating shrimp cocktails. You're in the back of wherever you bump in an air-conditioned car with the cows. Yeah. Getting somebody out of the house, I'm telling you right now. Now I'm in LA. I know you're in North Orange County. Orange County's a little better, but LA County. I mean, on a business level, I've just given up getting anybody out of the house. I mean, I'll refer customers to attorneys who specialize in this, and I work with all of them. And I have 8 or 9 evictions going on at various stages and different probates I have going on right now. But the reality is, as a businessman, I don't know if I'm ever going to get paid on those deals. It is just a nightmare getting tenants out today.
It's very tough, particularly family member tenants.
Exactly.
We just go through the eviction process. We'll get them out eventually. LA, of course, is the hardest place to do this. But it's the brother, and it's 2 reasons. Not only it's the family drama, but now it's emotional. Do I really want to evict my brother or sister? Now my nieces and nephews are upset with me. but they're the bad guy. They're the ones who are staying in the house when they're not. So that goes back to planning. I'll stress this again. When I'm sitting with mom and dad, I just don't say, "What do you want? Three ways, great." Is somebody living in the house right now? Do they intend to? Let's put provisions in that. If your son's living with you, let's say he's got to get out within 3 months. Otherwise, all attorney's fees and expenses will be reduced from his inheritance. We won't need a court order for that. We'll just reduce it. We can use the heavy stick to make sure that this trust is administered properly.
And you say that, just to clarify, in my experience, if there's, let's say, 3 beneficiaries and one's living there unreasonably without authority, they are commonly charged back fair market rent for that time and commonly charged all the fees to evict them, all legal fees. But that doesn't happen to the very end once you get the guy out 3 years later. But by putting it in the trust up front, I think the power of that is not, I don't know how much stronger that is legally. I mean, you can debate that, but what's clear is it has an emotional advantage that you send that to the beneficiary and say, look, it's a black and white right here that all this is deducted from your side. And like you said, we'll need a court order. Well, you probably still, you got to collect somehow, or you got to figure out some way to get the money. But it's certainly emotionally, my experience is, in those cases where trusts write that in there, that's a powerful stick.
Hugely emotional power play there, for sure. But it also it can be enforceable without court, because now, you go through eviction, or you hire me, or whatever we need to do, and we've spent $10,000 to solve this problem your sibling caused. Well, then at the end, now we have to go to court and get a court order that we're going to charge his share or her share. But if it's in the trust, we just do it. When we do the math, there goes minus 10 grand for their column. So planning and figuring out what's going on in your lives, who's living in there, who's going to take care of you when you're older, and is somebody moving in with you? Those are the things we need to consider.
Yeah, and I think like everything else in life, if you plan ahead of time, you have the opportunity to perhaps get a better outcome. You certainly forgo that if you just let the cards play out on their own. And so it's always advantageous, I think, to plan ahead. Well, look, we've covered a range of topics here. We start off, very deep on Prop 13/19, which is an important issue. But obviously, you do, and any attorney who needs some help in that area, you're a great asset. But you also do more broad-based estate plans for consumers as well. And so somebody who wanted to get in touch with you to learn more about whether it be an attorney for help or whether it be a consumer looking for an estate plan, I think we have on the screen here the best place, and the website we have is CaliforniaEstatePlanningServices.com. Is that the best way to reach you?
That's it right there, California Estate Planning Services, CEPSlaw.com. Both will get to me. We just do a handful of things, and it's all in the same core of things, Bill. We'll do estate planning. We'll talk about taxes and property taxes and estate taxes, conservatorships, elder abuse, bad trustees. Maybe you're being accused of being a bad trustee. All those things, give us a call. We offer free consultation. Just mention you saw me here on Bill's podcast, and we'll get you a free consultation. And one emerging area that's kind of rearing its head again that people should be aware of is Medi-Cal. For the last year and change, we didn't have to worry about Medi-Cal. If you needed a nursing home or in-home care and needed to get on Medi-Cal, you could have unlimited assets. It was kind of a weird time this last year. Governor Newsom just announced that he kind of intends, and it's a little more complicated than just him, but it's intended that the asset limits get back into play. So if you're single, you can only have $2,000, married $3,000. Very, very complicated rule. So if you are a senior or your parent may need a nursing home one day, a skilled nursing facility, we need to plan to make sure that your parents qualify for Medi-Cal, and we don't have to pay the government back when they die. And we can meet both of those goals.
And that happens just because you're not paying while they're alive. I've seen this in probate many times. Usually it's like about 2 or 3 months after you file the probate, they send the request for creditors out, and everybody kind of forgets about it. One day, boom, a bill comes in for $50,000. And the heirs are always like, what? What is this for? Well, I didn't know anything about this. Well, I don't know if you should or should not have known about it, but the reality is, if you fail to plan, you're planning to fail. And this is one of those things where, and I think Medicaid, the Medi-Cal here in California, Medicaid nationally is a program under a lot of financial pressure. They're going to look for ways to get more money. Nobody's looking to hand out any more money in these programs now. They're all going to be looking for more assets. And if you're rich with a lot of assets, you should expect they're going to try to find ways to get bills to you.
Right, Bill. And I'll tell you, most people who call me, most kids particularly, I'm never going to get mom or dad on Medi-Cal, or never going to go into a nursing home. There's a reason why there's dozens and dozens of skilled nursing facilities in every city. Nobody wants to go there, but they're all filled to the max because life happens. People do slip and fall and break their hip, and that is the best spot for them for a few weeks to a few months. So even though we're not planning to go to a nursing home, and that is never my goal to put mom or dad or you in a skilled nursing facility, we just got to plan for it, and it's kind of like insurance. Let's buy this fire insurance and hope we never use it.
I went through, I got a reality check on that. My wife, unfortunately, was battling cancer 2 years ago. Thank God she's cancer-free. But at one point after surgery, she had to go to a facility, and Medicare, because she was over 65, covers an amount for a couple of weeks, and it is actually pretty generous benefit, but it's limited how many days you get in your lifetime. And I said, well, what happens after that? I said, well, you have to pay on your own. What's the rate? And it's like ridiculous times 2 is the daily rate for this program. Well, how do people manage that? Well, one answer is many people come through Medicaid. And how do you do that? You plan ahead, because we had the assets. We'd have to give up everything and run it out to $2,000 to $3,000 before we qualify. But you can set up with a proper plan so that those assets are protected. And obviously that's result of a long conversation you're going to have with people. But what I discovered was that that is why the plan is in place, to protect the surviving spouse, so he doesn't have to be indigent in my case, because the party is. So it's one of those things where you may not ever need it, but boy, if you need it, that money runs fast.
Oh, super fast, Bill. And so just to kind of leave people with a brief how that works, there's kind of 3 stages for the skilled nursing facility. Day 1 through 20, Medicare's got you covered. Day 21 through 100, you're on your own, partially. Medicare's got you covered, partially. That 80-day stretch, it's about 14 grand of your copay. All right, so most people will figure that out and pay it. Day 100 and beyond, Medicare turns off. You better figure it out, because otherwise you're going to be spending 10 to 20 grand a month. So how do you figure it out? Medi-Cal. Most people call their firm in that stretch of day 21 through 100, where they now realize on day 21, the hospital staff or skilled nursing staff is telling them, hey, we're going to start having copays. That's when people start freaking out and saying, what do you mean? What's Medi-Cal all about? And then they call us. If we can plan ahead of time, it takes sometimes several months to plan for Medi-Cal. Right. So the sooner you call us, the better, but not everybody will use Medi-Cal. But again, just like everything else we do with property taxes or estate plan or litigation, we have free consultations with Medi-Cal. Just mention Bill.
Well, it's one of those things where I think none of us want to have to use this, because it's designed, for people with great financial need. But on the flip side, I've paid a lot of taxes in my life. It was interesting. When I started Medicare, when I turned 65, I had private insurance through my business. The private insurance company said, no, we don't cover you after 65. There is no private insurance for that, or at least the program I had at the time, I think it was Blue Shield Anthem. And then the Medicare was much better coverage than I had through private insurance. And at first I felt a little guilty. I'm on Medicare. I've never needed a handout. Why am I? Well, yeah, I said, look all the tax I paid over the years. My Social Security money that I'm never going to get because I'm too rich to get it. And Medicaid or Medi-Cal is one of those things where if you properly plan and you're a taxpayer, that's what we pay these taxes for. That's why we live in California and pay taxes. Why we live in the United States and pay taxes for these programs. So I would say, don't let your ego get in the way here. Much better to be able to have proper care for your family member. It's hard to get into facilities. When my wife was going through this, there were not a lot of empty beds. It was like a competition to get in. And they don't want to hear you talking about how you're planning to pay for it. They want to know that you're ready to go. And so much better to have these things thought of ahead of time. And so talk to Josh, see if that's something you need to get prepared for. Again, CaliforniaStatePlanningServices.com is the website. The phone number you can call for free consult, 714-584-5009. Josh Ramirez, attorney in Northern Orange County area, serving all of California. Thank you so much for your time again today. As always, I learned so much when we talked together.
Thank you for having me, Bill.
And for the rest of you, this is Estate Planning Weekly. We get together every week and talk to leading estate planners as well as vendors that support the business. If you have more information, you can go to the Facebook group and put questions there if you're looking for referrals. If you like this, please like it, subscribe. If you're an attorney who would like to be interviewed on this, please reach out to me. I'd love to talk to you about that. Or if you have a great attorney that you want me to talk to, please put their information in there as well. And as always, make today your best day ever.